We're waiting Roberto Armendariz and Jose Luis Cardenas. Mr. Anchondo, I didn't see any plea paperwork on Mr. Armendariz.
That is correct, Judge. So let me, if I may, indulge me. I spent the last part of the morning here and afternoon at the annex with Mr. Armendariz. I went down to speak to him about the plea offer and whatnot, and Judge, he wants to be able to tell you why and certain things as far as the reasons as to his non-compliance on the probation. I don't know if you want to set it for a revocation hearing in that regards, or if you would like to set it for a status with that.
We can do a revocation hearing in person. That will mean somewhat of a delay. I'm sure you advised your client of that.
I did, Judge, and he understands that.
We're looking at, we can do October 17th at 1:30 p.m. and we can go ahead and bring him over in person.
October 17th would work. I am just going to advise that I do start a capital murder on the 13th in the 384th. If I'm able to go ahead and take a break on that, then I will definitely head over to your court and
let's not do that. Let's go ahead and move it up to the 10th. I just think that there's going to be a trial setting here. So we'll go from there. Okay.
Okay.
So October 10th at 1:30 p.m. in person.
Sounds good, Judge.
Thank you.
Thank you. May I be?
Oops. I removed him. Okay. The next one is going to be Cardenas. So I think, does Annex have Cardenas, Ms. Bayan? I thought we had an agreement on the 4 TDC and I didn't see plea papers.
Your Honor, there's a reason you didn't see plea papers. I did go discuss everything with him. I've been in communication with Mr. Vandenberg. There was a misdemeanor I wanted to clear up as it was alleged. And I just, in Mr. Cardenas' presence, he has some concerns and I would like to go over them with the court. Mr. Cardenas has—
Let me call him then so we can make sure we're on the record.
He has 3 different felonies that we are dealing with.
Ms.
And
Bayan,
his time credit is off.
Can't hear you, I think.
Yeah, there's something. I'm actually also trying to mute her and it doesn't let me.
Yeah,
Is anybody having issues with Zoom today?
She froze, Judge.
Yeah, I know. We'll have to, let me remove her and see if we can't get her to come back on. Mr. Cardenas, we're having some issues with some internet connections here, so we'll come back to you. All right, I just hoped we could kind of knock those out quickly if there was an issue. Who's next, Mr. Maruco?
Bottom of page 25, Judge. In cause number 2020-0D00795 and 2022-0D03665, State of Texas versus Ebony Martinez. Announcement of counsel, please.
David Vandenberg on behalf of the state is ready.
Mr. Huffman, is this yours?
Yeah, it is, Judge. Good afternoon. Rick Huffman on behalf of Ms. Martinez, we're ready.
And Ms. Martinez is appearing remotely from the downtown jail. We are scheduled for bond hearings. I believe, Ms. Serrano, are you here on this case as well?
Yes, Your Honor, I am. Brianna Serrano for adult probation.
And I did review the case summary. I'm very familiar with Ms. Martinez. And so before we approach the bond hearing, let me ask Ms. Serrano if I saw the recommendation for treatment. The court was wanting to ask if DWI court would be consistent with the recommended treatment. I'm very familiar with Ms. Ortiz. I don't think there was anything from the time that we hit the bench warrant. There's no new cases, right? We just lost track of her after she tested positive and we'd had some issues on the monitor.
Yes, Your Honor, there's no new cases. I've never actually met her.
Got it.
And she stopped reporting to probation January 2023.
Right. So let's put her in DWI court, Mr. Huffman.
That's a good idea, Judge. I haven't talked to her about that. Well, if I may, Judge,
sure. Go ahead.
I have not spoken to her about the DWI court, but I think that's an excellent idea. Judge, she's 21 years old, El Paso resident and US citizen. She has 2 children. The reason we're here, she's been in jail for 20 days, Judge.
Where are her children? That
With
huge
the
concern.
with the children's father, Your Honor. He's with their father, Your Honor. The main reason we're here today so soon is because she's 9 months pregnant, and she's having pains. She's ready to go, and she's so. I asked her mom to be here. Her mom is working, so I don't know if she's on the Zoom call. She has a place with mom, and I would ask the court to order. And she's been living with her now boyfriend, and everything's going well there. But I think it'd be helpful if the court had an extra set of eyes with her mom, who is present and who has a room for her and is willing to provide support. I have not spoken to her about the DWI court, Judge. I think it's a good idea. I was just hoping maybe that we can, if the court would consider letting her out, just for that reason of her being so pregnant.
Where is mom? Is she here? Is she on the screen?
I spoke to her probably 5 minutes ago. She said she was going to try to make it, that she was working, and that it doesn't look like she's on, Judge.
What is her name? And Mr. Marufo, have we confirmed who's in the waiting?
I have a Felina Perez and a Kim Meredith.
I know Miss Perez is, I think that's her, Judge.
Ms. Bettis, would you unmute, please?
Okay, there.
Are you?
Sorry, it's because I'm at work and it's kind of loud, so I don't know if you could hear me or not.
I can hear you, ma'am. Are you Ms. Martinez's mother?
Yes.
Okay. All right. So, Mr. Huffman, you asked her to be present here. Did you have anything from Ms. Bettis for me?
I just wanted to demonstrate to the court that her Miss Martinez's mother is present, supportive, and willing to basically keep an eye on Miss Martinez. She reports that Miss Martinez has been doing fairly well. Unfortunately, not doing so well on probation, but she's been doing well, basically keeping her head down at home with her boyfriend. But I think it would be a good idea if the court order Miss Martinez to live with mom. If the court would release her, which I'm hoping the court would consider that.
Ms. Bettis, wasn't your daughter living with you when she picked up the DWI? And I don't want to know about the DWI, but she was living with you, or where was she living?
No, she had her own apartment at that time. And she's yeah, I think she had just had her other baby, well, the second one. And honestly, I think honestly, from my opinion, I think she had a little bit of postpartum, because she was really like depressed. She had her new apartment. She wasn't with the dad at the time, so she was at the apartment with the kids alone.
All right. Oh, what else? Thank you, Ms. Bettis. I'm sorry. I just want to get back to Mr. Huffman very quickly. Mr. Huffman, do you have anything else?
Well, I mean, no, Your Honor, I would, you know, if the court, I would like a chance to talk to Miss Martinez, maybe in a breakout room about that DWI court. I think she would have to get qualified or something. She would have to qualify for the DWI court, so she'd have to get interviewed. And I don't know what the process is with her being in jail.
Okay. All right. Thank you, Mr. Huffman. Ms. Serrano, were you going to say something there? I saw your screen light up.
Yes, Your Honor. I just wanted to make the court aware too. Her case ended August 17th of 2023, and it's only being held open by the MTR. So she will need an extension for however long the court
Okay.
deems necessary.
All right, thank you, Ms. Serrano. Mr. Vandenberg, what's your position on the bond?
Well, the state's position is that she has shown herself to be a danger to the children. The DWI occurred when there was a 7-month-old daughter and a 3-year-old. She had been drinking green tequila buzz balls. The intoxication level was 0.15 and 0.157. So if she is released, she shouldn't be allowed to be driving, Your Honor. And the burglary habitation was also a strange event where she broke into the back of a house through a window, broke open a window through there. State opposes the release because she would be a danger to her family and to the community at large, Your Honor.
Okay. Is she on deferred on the burglary habitation?
Yes, Your Honor.
All right. Okay, so thank you, Jasmine. The court is comfortable. I'm very familiar with Ms. Martinez's cases. She tested positive for cocaine, drank some vodka when she just had that baby, separate and apart. That was part of the issues with her probation. So I am going to release her and modify her. I'm going to modify her somewhat per probation's recommendation, but with the intention to have her screened for DWI court. She is to reside with mom, subject to all other conditions. We are going to extend her on the burglary habitation for 1 year. Well, when did she, 8/17? Yes, we can do 1 year. We can do 1 year. And then we still have our little DWI with a child. We need to set her for trial in that case. Oh, no, correct. Probation doesn't have her screened for DWI court. Mr. Huffman, you have to go over there and look at the DWI court per the new case. But I'll tell you this, once she gets screened, if she's accepted, both cases are going to be modified for her to attend DWI court. So in the event she does not qualify, I still want her screened through probation for additional substance use, alcohol use. I want her modified for parenting classes and MHI, screen for MHI caseload. She's about to have another baby, so I don't want us spinning our wheels here. Mr. Huffman, I can't hear you.
Your Honor, I'm not sure if she still has the monitoring device. I don't know what the situation is there.
Okay, well, if she doesn't, it's still part of her conditions, so she's gonna have to get it.
Do
I'm
we
not
know-
gonna restrict her driving, but she has to have a monitor.
Understood, Judge. And she'll get that as soon as she gets out, right, Mom? We'll be able to get that?
Ms. Bettis, you're muted. That's fine. I mean, it's not on Ms. Bettis to, you can talk to her about that.
Sure, I will.
And it is a portable monitoring unit, okay, with the GPS.
Yes, Your Honor.
All righty. Everyone else good on that? All right, thank you very much.
Thank you, Your Honor.
Thank you for your
May I
time, Ms.
excuse
Bettis.
Your Honor?
You may. Thank you, Ms. Serrano. Who's next?
Judge, may I?
Yes.
Downtown, can you go back to the first one and log in when you're there?
Yes, sir.
Okay, thank you. I believe Ms. Payan is connected, Judge.
All right, Ms. Fayan.
I'm in the courthouse and it kicked me out, so I'm sorry.
I had some issues. I've continually kind of gotten kicked out of Zoom while we've been on today. So that's why I asked if anybody was experiencing any issues. Maybe it's just you and me. But
It's our
Mr. Cardenas, please.
And next, may we have Cardenas Jose Luis?
Go ahead.
In cause number 2020-0D04583 and 2019-0D05147 and 2020-0D04598, State of Texas versus Jose Luis Cardenas. Announcement of council, please.
David Vandenberg on behalf of the state is ready.
Edith Payan on behalf of Mr. Cardenas, and we are ready.
And Mr. Cardenas is appearing remotely. We're scheduled for probation status hearings at the last setting. I believe we had discussed an offer of 4 TDC on the 3rd degrees and 2 years on the state jail. The court has not received paperwork. Ms. Payan.
Thank you, Ernest. I did meet with Mr. Cardenas Friday for some time, and we did go over the paperwork. He just wants to be sure. The problem, Your Honor, is this: his credit, he has different credit, and the judgment. So although there are different dates of offenses, the judgments for all 3 of those cause numbers said the sentences were to run concurrent. And so, as I was saying earlier, Ms. Welch went through everything very thoroughly. And in cause number 2019-0D05147, he has 662 days. And in the other cause numbers, 2020-0D04598 and 2020-0D04583, he only has 434 days. And in fact, right now, he's even only booked on one of those. Either way, he's 220 days off. So we would be asking the court, should the court accept the 4 years TDCJ, for the court to give him equitable credit, and in the judgments on the revocations, give him those extra 228 days so everything is evened out.
Well, just because they run concurrent doesn't mean they get backdated to a prior plea. So I'm not really inclined to do that. He has 434 odd days on 2 of the cases, and it is running, his time is running concurrent. And if he's not booked on one of those right now, I will certainly give him credit for this ongoing incarceration, but he's not going to get 600 days on the 4583 and the 4598.
Thank you, Your Honor. And so then at the very least, his most recent booking date was June 29th, 2023. And he is only booked on the 2019-5147. So would the court grant the credit from June 29, 2023 till the date of the plea?
Yes, ma'am.
Okay.
On
Thank you.
4583 and 4598. So with that, if we have an understanding and your client wants to go forward, I'm going to reset him for 30 days for a plea of true. Well, actually, probation status hearing anticipating a plea of true.
Okay, Mr. Cardenas, do you understand that?
Really, I'm not trying to. I don't understand about the time, the equity time. Like, if I was booked on those charges, how come I'm not getting credit time?
So I'll go explain, and Mr. Cardenas, that's the whole issue. You weren't booked on them. So the court will give you the extra time since you've been booked in June 29th, because you're only booked on the 5147. So that's going to be almost 90 days. But as far as the rest of the days, the court cannot give that credit. So I will go talk to you again, and then we'll follow up from there.
How long is this process going to take? I'm just trying to go ahead and sign and get out the way.
If that's what you want, you're signed. I'll turn in the paperwork, but you had some concerns about your credit. So I can go see you Monday to what?
What is it that they're crediting in total? What is it that they're going to give me credit?
Mr. Cardenas, I'm going to refer you to your attorney. I am resetting your cases for 30 days. Ms. Payan, if he has, well, he's walked off, so he must not be too concerned.
Right.
Thank you for your time, Ms. Payan.
Thank you.
Who's next?
Up on page 27, Judge. Annex, may we have Tristian? Sylvia Tristian?
Good afternoon, Mr. Bean.
In cause number 2023-0D03155 and 2023-0D00951, State of Texas versus Sylvia Patricia Tristian. Announcement of council, please.
David Vandenberg on behalf of the state. I have to say, I'm not ready. This is a plea hearing. I don't have the plea papers on this.
6 deferred, urine and breath analysis, TAP 2,000. Probated fine, 250 hours of community service, no contact with the complainant, dismissal of cause number ending 0951.
And Judge, if I may add, pursuant to email conversations I had with Ms. Ortega, the last one being on August the 16th of this year, there's 2 misdemeanor cases that she's going to be dismissing as well. And those cause numbers are 2023 0C0 0074 and 2023 0C0 5107.
Mr. Vandenberg, if you need a little more time, we can come back to Ms. Tristan.
Could you repeat the state's recommendation on that, please?
6 deferred, urine and breath analysis, TAP $2,000 fine, all probated, 250 hours of community service, no contact with the complainant. I did not see the notation of the dismissals on the misdemeanors. I did, however, receive the dismissal on cause number ending 0951. So I don't have a problem if you want to come back to this case, Mr. Vandenberg, but
That would be good.
okay, so we'll come back to this one, Mr. Bean.
Very
Who's
good.
next?
I'll stand by.
Thank you.
Mr. Vandenberg, do you want me to forward you the email on the misdemeanor cases from Ms. Ortega?
Please do.
Okay, what is your email?
It's d.vandenberg.
Okay, I'll send it to you right now.
Very good. Thank you.
Thank you.
Thank you.
Who's next?
Towards the bottom of page 25, Judge.
Mhm.
In cause number 2019 0D0 1480 and 2019 0D0 3343, State of Texas versus Rudolph Edward Helsovar. Now it's been a counsel, please.
David Vandenberg on behalf of the state. The state is ready.
Veronica Teresa Lerma, Your Honor, on behalf of Mr. Helsovar.
Okay, good afternoon. We are scheduled for bond hearings in each of these cases. Is that your client appearing from the downtown jail, Ms. Lerma?
Yes, Your Honor, it is.
Okay, I just want to double check. I don't usually have one that has days in jail this high. Was it on the examination and maybe the restoration?
Yes, Judge. He was recently transferred back to the 210th.
Got
He
it.
was in the 384th for quite some time. And so really, that's the reason it's so long. It's not that we've been neglectful of this case.
Got it. You may proceed on your bond hearing.
Yes, Judge, as there's the 3343 case is an aggravated assault with a deadly weapon. I understand there's a $200,000 bond. The assault on a peace officer, the 1488 case, has a $60,000 bond.
Thank you.
Mr. Helsovar has been in state custody now for over 1,000 days on these cases. There was some competency issues. He has been restored to competency and transferred back to this court. The initial offer for this case was 10 deferred. This was back in 2019, 10 years deferred adjudication or 4 TDC, which I believe now he has more than enough time credit for. However, there are issues that this case may proceed to trial. And so we're asking the court to consider reducing his bond. Also, Mr. Helsovar would live with his mother pending this this potential trial or plea. He would reside at 486 Place Road here in El Paso, Texas. He is indigent. I am appointed to represent him in this case. Unfortunately, his family has very or little money to post any kind of bond. So we're asking the court to consider the lowest amount of surety bond combined with a personal recognizance bond. He is working on his GED. He is a United States citizen. He is disabled, Your Honor, and his mother would be his provider and caretaker. And he would be pending a SSI or disability application. Currently, he's not able to work, but because he's in jail, he can not make an application for disability just yet until he's released.
Got it. Got it. Anything else?
And I haven't had a chance to speak with the ADA on this case, Your Honor. I don't know if it's Ms. Ortega or Mr. Vandenberg, but I do need to speak with them as well regarding resolution of this case.
You can call me directly.
Okay, very good. Thank you.
Mr. Vandenberg, what's your position on the bond?
The state is opposed to it, Your Honor, because if you look at the facts on these two matters itself, the one that ends in 1488, the facts show that Mr. Helsovar threw a rock through a neighbor's window about midnight. He says that the neighbor killed his cat. So in revenge for that, he threw this rock through the window, almost hitting the occupant. Police were called. When the police arrived, Mr. Helsovar attacked the police officers and attempted to strangle one of them. In the other case, 3343, he pointed a gun, pistol at his stepfather, threatened him through that, and then fired the gun into the air. There seems to be a history of schizophrenia with Mr. Helsovar, and we're not certain that he is stable enough to be walking around the community. He has a prior AFE from 2002, and he has another aggravated assault in the year 2000. So the state is very concerned that he has not shown a track record of enough stability to be in the community, Your Honor.
Ms. Lerma, what is the plan for his stability if he's released?
Judge, I think part of that would be the conditions that the court is going to have to place. He would have to be on a mental health caseload. He would have to follow whatever medications his doctors recommend for him. I don't have a specific list from the doctors, but I do know that they, in one of their reports, they listed all of his medications that he must take.
Yeah. You know, for the longest time, we were enlisting the help of jail EHN to come up with an exact plan, set him up maybe with an appointment upon release, ensuring that we have, I'm assuming he's on some type of medication, ensuring that he had something of a supply of medication if released, things like that. That's the type of specificity that I want to see before I will consider reducing the bond, because obviously this has been such a long process, and the crux of that process has been the mental health concerns. So for now, I'm not denying it. What I want to do is, I think realistically, Ms. Lerma, we're looking at least 30 days to give EHN. Do we have any documentation from EHN? Have they been meeting with him while he's in jail? Have they looked at anything?
I haven't received anything, Judge, so I'm going to have to make some phone calls and ask the 384th to provide some of those documents that were sealed.
Ms. Lourdes Garcia had been the individual at EHN that would review cases. It's been so long, I think, since I've done one of these where she's been able to assist the court at the bond level, that I don't want to represent absolutely that it's her, but I know she's a starting point and could get you to the right place. Quite honestly, if they're able to do it more quickly than that, we can reconvene on the bond sooner, but that is what I want to be sure of. Certainly, you know, if that's the issue, we just want to make sure he's in the right place. Right now, though, so I'm going to reserve ruling on your request for that purpose. With the anticipated 30-day reset, I also want to make sure we get a trial track squared away on both of these cases. And I don't know in terms of, because they're a little bit older, are the cases complete? Have you had a chance to look at at the portal and see if there's anything outstanding? Because I know you need the time to prepare if that's where we're headed. But I also don't know that he's not going to be in custody. So the sooner I can get him a trial setting, the better.
I've looked at Portal, Judge, and as it hasn't been updated for a while. So if there's any new conversations with any of the CWs or anything that has arisen since the time of the 2019 update, then that's what I would ask be updated. Other than that, I think we have everything.
With that, then maybe I'll just reserve setting the trial. But just know, counsel, that I'm going to really try and put this within 6 months if we're indeed going to trial because of the amount of time he's been in custody. Okay?
Yes, Judge.
Thank you, Ms. Lerma. Thank you, Mr. Vandenberg.
You're welcome.
Thank you.
Who's next?
Judge, may I?
Yes.
Downtown, can you go to the fourth one? Skip the third one, go to the fourth one, please.
Mr. Sanchez Leonel, sir?
Yes, sir.
Yes, sir.
Okay, we'll see you there.
You're right.
Middle of page 25, Judge.
Mhm.
Annex, may we have Roberto Olguin?
Yes, sir. For me? For me? All right.
In cause number 2023-0D04920, State of Texas versus Robert Olguin. Announcement of council, please.
David Vandenberg on behalf of the state of Texas, and the state is ready, Your Honor.
Good afternoon, Judge Jesus Solias, on behalf of Mr. Olguin, we're ready as well.
And Mr. Olguin is appearing remotely from the jail annex. We're set for a bonding hearing. Mr. Olivas, you may proceed.
Thank you, Judge. Judge, by way of background, we had a bond hearing earlier this month with the jail magistrates. There was a reduction, however, my client has not been able to make the bond. Consequently, we've come to you and with the hopes of getting a further reduction getting a further reduction. My client, Mr. Olguin, Judge, is 48 years of age. He is a lifelong resident of El Paso County, Texas. At the time of his arrest, he was living at 908 Orndorff Street in Fabus, Texas. It's not the same address as the complaining witness. He understand that he's going to understand that he cannot be anywhere within close proximity to the complainant witness of this case, that will be reason enough to revoke him and put him back in jail. I'm not sure if he was working. Mr. Olguin, were you working at the time of your arrest?
Yes, I was. Yes, sir.
Do you still have your job waiting for you when you get out?
Unfortunately, no, not anymore. I have to look for employment.
Okay. How long have you lived at the address on Orndorff?
Going on 4 years.
Okay. And if you are granted bond and can make bond, is that where you'll be staying?
That's correct. Yes, sir.
Okay. Pass the witness, Your Honor.
Did Mr. Olguin ever live in California?
I think so. At the JMAC bond hearing, there was an issue that 2 DWIs came up on him out of California.
Okay. Got it. All right, Mr. Vandenberg.
The state opposes the reduction in bond, Your Honor. As the court has pointed out, he has a couple DWIs out of California, one's from 2013, one's from 2022. And alcohol, according to the report that we have, was involved in this current matter. He was known to the family as Uncle Bobby, performing massages on various members of the family, and that's when this indecency with the child occurred, Your Honor. The state would, again, object to a reduction in bond, especially with any kind of contact with children, especially teenagers. And he is a danger to the community because of his actions, Your Honor.
Anything else, Mr. Olivas?
Other than the one in Texas, Judge, I mean, California, here in Texas, all I see is a driver with license suspended.
Okay. All right. Anything else?
Well, I would request a further split on the bonds, Judge, if possible.
That request is respectfully denied. The bond is appropriate considering the nature and circumstances of the offense, the future safety of the victim, the community. Thank you very much.
Thank you, Judge. May I be excused?
You may. Who's next?
In on page 25, Judge.
Mhm.
Second one. Annex, may we have a Daipen, John?
Did you call Leonel Sanchez, Mr. Marrufo, or did I just not hear that?
I think they're queuing him up from the downtown jail. I'll
Oh,
tell you
okay.
right now, I'm not inclined to do a straight PR. I heard you and Mr. Vandenberg. Does he have any resources, Mr. Fernandez?
Very limited, Judge. He's I believe 20 years old or 20, just turned 21 actually, Judge, I think.
Okay. Yeah,
Um,
this is the one
he
that
was
they reported.
Yeah, he was working at Buffalo Wild Wings, but yeah, we'll go over that, Judge.
Okay. Is this Mr. Dypen? Go ahead.
Yes, that's my name, Your Honor.
Good afternoon, sir.
In cause number 2020-0D04582, State of Texas versus John Daipen. Announcement of council, please.
David Vandenberg on behalf of the state is ready.
Ada Paya on behalf of Mr. Dypen, we are ready.
And for purposes of the record, Mr. Dypen is appearing remotely from the jail annex. We're set for a status conference and we need to get a trial track going. Have you all had a chance to confer on the case?
Yes, Your Honor, we have, and Ms. Payan and I are talking about resolution on this. We're very close to something right now, but we're still involved in these negotiations, Your Honor.
Your Honor, I was able to speak with Mr. Vandenberg yesterday and I did get a plea offer from him. I just need to get out to the annex to communicate it to Mr. Dypen. My plan is to be able to get out there Monday or Tuesday.
Okay, we can reset this for 2 weeks. In the event that it is a plea, we anticipate we can do it then. So we'll do it at the jail docket. We'll reset the status. If not, we're gonna do a very quick trial track, okay?
Sure, and I guess what we could do, Mr. Vandenberg, is you could go ahead and send the plea papers. That way when I go out there, or that way we have them ready just in case.
Correct.
So we don't waste more time and I don't have to go out there twice. But I will let everyone know.
Okay, thank you very much.
Thank you.
Thank you. Thank you, Mr. Marufo. I think I'm done.
Thank you very much, Your Honor.
Have a good day, sir. Who's next?
Second one on page 26, Judge.
Mhm.
Annex, may we have Ramirez, Francisco Ramirez?
Is he downtown? Is that word? No. Oh.
And Judge,
Hmm,
this is my case.
yeah,
I think it's necessary that we do a safety plan. We need to get Mr. Ramirez some services, and we need to get him some possible housing. So I need to send my social worker out there. I don't have that ready. So we don't have a place to stay. We don't have services linked.
do you want to reset your bond? Are you wanting to reset today, or you want me to hear the bond?
Judge, can we reset for 1 week? I don't want to waste my bond hearing without, having that stuff ready for the court.
I'm gonna say reset 2 weeks.
Is that okay, Mr. Ramirez? Can we reset the case 2 weeks? Aye.
Oh. Mr. Huffman, can you do the Spanish?
Yeah, señor, ¿quieres hacer la cita en 2 semanas? Necesito preparar porque ahorita no está listo. Yo no soy listo, pero necesito 2 semanas para buscar un lugar para vivir y también servicios mentales. ¿Ok? Necesito 2 semanas. ¿Es ok?
Pero yo puedo vivir con mi hermana.
Okay, let me go ahead and stop it right there, Mr. Huffman. First of all, I need to know if we need an interpreter, if you want to do the bond hearing, or if you're waiving it, because I'm gonna get on the record.
Well, Judge, we'll do the bond hearing, Judge.
Calling cause number 2023-0, well, but we need an interpreter.
Oh, okay.
All right, let's move on.
I'm calling them.
Thank you.
Very good.
Bottom of page 26, Judge.
Mhm.
In cause number 2023-0D01938, State of Texas versus Leonel Sanchez Jr. Announcement of counsel, please.
David Vandenberg on behalf of the state is ready.
Good afternoon, Your Honor. Ruben Hernandez for Mr. Sanchez.
Is that your client from the downtown jail, Mr. Hernandez?
That's him, Judge.
Okay, we're set for a bond hearing. You may proceed.
Your Honor, Mr. Sanchez is a United States citizen, Judge. I believe he just turned actually 22, Judge. He was born in 2001, August of 2001. He's been detained, Judge, now for, I want to say, going on 3 weeks. So he's been in there for a while. My understanding, Judge, is he had missed his court date because he was not given notice by his previous counsel. And so he had been going to every other court hearing, had appeared at every other court hearing. He's not a flight risk, Judge.
So let me stop you right there because I thought I reviewed this one. Maybe I'm wrong. Isn't he the one that I believe the state had made an offer of 2 clean UAs for a dismissal, and lo and behold, he goes and comes up dirty? And so then that was the PR violation?
Judge, that was the original offer. My understanding is that they had tested him while he was detained. I don't think that was the original. You may be right, Judge. You may have better notes than I do, but
It's on the revo notice.
I think when I spoke to his father and him, Judge, it was my understanding was that he was not given notice of a court hearing. That's what they thought he was issued the warrant for. But Judge, whatever condition you deem is necessary for him, Judge. I mean, I've looked at the case, Judge. The lab results are inconclusive at best. So this is a state jail felony. He has no prior criminal history, Judge. Again, he's been in for 3 weeks now, or going on 3 weeks. So I think you've caught his attention being in there for 3 weeks, Judge. And whatever testing you want, Judge, you can do it once a week or whatever the court wants. I think ultimately this case will probably get resolved, maybe gets dismissed. Worst case scenario, Judge, it'd be a probation case, I think, deferred. I think the offer right now is 2 straight, but I mean, no priors. I would assume the worst case scenario would be 2 deferred, or a lot of these cases, they give them 1244Bs deferred or time served. So he's not a flight risk, Judge. I think we can get this case resolved. Being in there for 3 weeks has caught his attention, Judge. I can guarantee he's a young man being in jail for that amount of time. He's never been in jail for that long. And so we'd ask the court for a PR bond. He was given a PR bond on the other on his the 2 misdemeanor charges that he caught along with this same case. His funds are limited, Judge. He was working at Buffalo Wild Wings before he was picked up. So we'd ask the court for a PR bond, Judge, a full PR bond, whatever condition the court deems necessary.
Just so we're clear, the personal bond violation affidavit, PR officer was notified by District Attorney Ms. Ortega of defendant's offer for dismissal, which required 2 clean UAs by next court hearing. Defendant was advised to report. He completed a urine sample and results came back presumptive positive for cocaine and marijuana. Defendant admitted to PR officer he had used illegal drugs. No further issues to report. There might have been a failure to report. I don't recall that. I just recall the alleged use. Mr. Vandenberg, what's your position on the bond?
We oppose reduction, Your Honor, for the very reason that there was an offer. He turned out to test dirty. The offer was that it would be dismissed for drug counseling and 2 clean UAs, but because his test turned out dirty, that has been revoked, and the new rec is 2 straight UABAs, TAP 100 hours, community service, $1,000 fine, and no early term. So Mr. Sanchez has shown that he's continuing on the same path that got him in jail in the first place, Your Honor.
Anything else, Mr. Hernandez?
Judge, just without going again too much to the case, there's no video. The reason for the stop was supposed no light over the license plate. We have pictures of the very next day, the father, the lights were working just fine. So there's issues with the stop, and then the results themselves, Your Honor, on the from the labs are inconclusive as to the THC having to be the 3%. So, you know, there's a lot of issues with the case, Judge. So we'd ask the court to grant the PR bond, and whatever condition the court deems necessary, Judge, he can do you know, weekly test or whatever. He make sure he's clean.
No. We've already tried that route. So although I'm not granting your request for a full, putting it back on PR bond, I'm going to reduce his bond to $1,500 cash surety. He is set. What is this P file case?
I believe Judge, it's a misdemeanor.
A possession of marijuana. Okay. I am going, it's going to be a $1,500 cash surety bond. He is set for trial in October. I don't see a motion to suppress filed. So if I'm starting to hear that, I would really encourage you, Mr. Hernandez, to get that filed, request a hearing so we can have that heard prior to our jury trial date of October 20th. Okay?
I'll get that filed, yes, Your Honor.
Thank you very much.
Thank you, Judge. I appreciate it.
Take care.
You too,
Who's
Judge.
next?
Mr. Vandenberg.
Thank you, sir.
Mr. Vandenberg, are you ready for the plea?
Yes, we can go ahead with that.
Annex, may we have Christian, Sylvia?
Thank you for your patience, Mr. Bean.
Not a
Ms.
problem, Judge.
Ms. Tristan, you can hear us okay? Okay. Whenever you're ready.
In cause number 2023-0D03155 and 2023-0D00951, State of Texas versus Sylvia Patricia Tristian. Announcement of counsel, please.
David Vandenberg on behalf of the state is ready.
Woodrow Bean, Your Honor, on behalf of the defendant, ready to proceed.
And I think Mr. Bean, thank you, you've muted. All right, and Ms. Tristan is appearing remotely from the jail annex. I do recall, Ms. Tristan, having received a written acknowledgement from you agreeing to do this over Zoom. Is that correct?
Yes, Your Honor.
Okay, I can tell you right now, I'm going to need you to speak up quite a bit because it's hard to hear you, okay?
Yes, Your Honor.
Okay, thank you. Ma'am, in that case, we're going to go ahead and get started with your plea, at least as to one of these cases. In order to get started, I need to swear you in, ma'am. Would you raise your right hand, please? Do you swear or affirm that any testimony you provide will be the truth and the whole truth?
Yes, Your Honor.
Thank you very much. You can put your hand down. Please state your name and date of birth for the record.
Sylvia Patricia Tristan, April 14, 1982.
Ms. Tristan, as I mentioned, I received documents regarding your plea today, the first of which is marked as State's Exhibit number 1. Those are the plea papers in this case. Within that document, you're guaranteed certain rights, including the right to remain silent, the right to trial by jury, the right to counsel, the right to confront and cross-examine witnesses, and the right to call witnesses on your behalf and in your defense. Ms. Tristan, do you recall reviewing State's Exhibit number 1 with your attorney and signing that document?
Yes, Your Honor.
Did you understand everything contained within that document?
Yes.
Mr. Bean, have you had more than 10 days to prepare a defense in this case?
I have, Your Honor.
And did you explain the plea papers to your client?
I did, Your Honor.
Do you believe she has understood the admonishments, rights, and consequences of giving up these rights by entering his plea today?
I believe she has, Your Honor.
Her plea today, sorry. Ms. Tristan, are you satisfied with your attorney's representation of you?
Yes.
Any reason to believe, Mr. Bean, that your client is not presently competent to enter her plea?
No, Your Honor.
Ms. Tristan, have you ever been found mentally incompetent by any court?
No.
Ever been examined by a doctor or psychiatrist who has found you mentally ill?
No.
So based on your testimony, your attorney's representations, and my observations of you, I'm going to find that you are competent to enter your plea today. Ma'am, are you a U.S. citizen?
Yes.
Where were you born?
I was born in Delicias, Chihuahua, Mexico. I am a naturalized citizen.
U.S. citizen? Okay. In this case, ma'am, in cause number ending 3155, you're charged with the second-degree felony offense of burglary of habitation. To that charge, ma'am, what is your plea? Guilty or not guilty?
Guilty.
Are you making your plea freely and voluntarily?
Yes, Your Honor.
I will find you are making your plea freely and voluntarily. Mr. Vandenberg, would you summarize the evidence, please?
Yes, Your Honor, had this matter gone to trial, the state of Texas would have been able to prove beyond a reasonable doubt that on or about the 30th day of May, 2023, and anterior to the presentment of this indictment in the county of El Paso in the state of Texas, Sylvia Patricia Tristan, hereinafter referred to as defendant, did then and there intentionally or knowingly enter a habitation without the effective consent of Daniel Vega, the owner thereof, and attempted to commit or committed the theft of property. At this point, Your Honor, the state would request that exhibits 1 and 2 be admitted.
No objection.
This to the 3914?
Yes, Your Honor.
No objection, Mr. Bean?
No objection, Your Honor.
States 1 and 2 are admitted. What is the plea agreement?
The state recommends that the defendant serve 6 years of deferred probation under the rules of the Texas Rules of Criminal Procedure, be subject to UABA's TAP, 250 hours of community service, $2,000 fine, have no contact with the complaining witness or the incident location. In addition, the felony offense of 2023 0D0951 would be dismissed, and 2 misdemeanors would be dismissed. 2023 0C00074 and 2023 0C05107.
Mr. Bean, is that your understanding of the plea agreement?
It is, Your Honor.
And Ms. Tristan, is that your understanding as well?
Yes, Your Honor.
Understand that the plea agreement is not binding on the court. However, if I were to reject it, I would allow you to withdraw your plea. If I follow the plea agreement, you may not appeal this case except on matters raised by written motion and ruled on before trial or by permission of the court. The next document I'm going to ask you about is a 1-page document entitled the Trial Court Certification of Your Right to Appeal. It is a document that explains your appeal rights. Because this is a plea, bargained, or negotiated case, you do not have an automatic right of appeal. Ms. Tristan, do you recall reviewing the trial court certification with your attorney and signing that document?
Yes, ma'am.
Signed by your attorney and signed by the court as well. Finally, the motion for deferred adjudication. Ms. Tristan, do you recall reviewing with your attorney the motion for deferred adjudication and signing that document?
Yes.
Mr. Bean, did you explain to your client both the benefits and detriments of deferred adjudication?
I did, Your Honor, in great detail.
Ms. Tristan, do you understand that if you violate a condition of deferred adjudication, the court can proceed to sentence you up to the full range of punishment for this offense, which is anywhere between 2 to 20 years in TDC in prison? Do you understand that?
Yes, Your Honor.
And are you asking the court to grant you deferred adjudication?
Please, yeah.
I will find in this case that there is sufficient evidence to substantiate a finding of guilt. However, I will not enter a finding of guilt at this time. Instead, I will defer further proceedings and place you on deferred adjudication community supervision pursuant to the plea agreement for a period of 6 years. There will be a $2,000 fine. The entirety of that is probated, 250 hours of community service, urine and breath analysis, screen for TAP, no contact with the complainant or the incident location. There is also a dismissal. I believe I have already signed it in cause number 2023 0D00951. Additionally, the misdemeanor dismissals will be routed to those courts for the judge's signature. Is there anything further, Mr. Vandenberg?
Not from the state, Your Honor.
Mr. Bean?
Nothing for the defense, Your Honor.
Ms. Tristan?
Thank you. God bless you.
Same to you, man. Good luck to you. Thank you, Mr. Bean. You are excused.
Thank you, Judge. Have a nice day.
You too. Who's next?
Back to Mr. Ramirez. We have Mr. Cifuentes here.
Okay.
Annex, may we have Ramirez Francisco?
We're ready, Mr. Cifuentes.
Please select the appropriate language.
In cause number 2023 0D00788, State of Texas versus Francisco Ramirez. Announcement of council, please.
David Vandenberg on behalf of the state is ready.
Rick Huffman on behalf of Mr. Ramirez, we're ready.
And Mr. Ramirez is appearing remotely from the jail annex and utilizing the assistance of a court interpreter, Mr. Jesus Cifuentes. We are scheduled for a bond hearing. Mr. Huffman, you may proceed.
Thank you, Your Honor. Mr. Ramirez has been in custody for 103 days on a $30,000 bond for this case. Your Honor, he was living with, okay, the case is against, I'm sorry, the complaining witness in this case is his sister, who has signed a non-pros. I've spoken to her, to Mr. Ramirez's sister, who has informed me that she does not believe Mr. Ramirez is a threat, and she does not want to prosecute, and she is concerned about her brother, and she wants her brother out of jail. Mr. Ramirez was living with a different sister who has since gone to basically an old folks home. So that house is no longer available to Mr. Ramirez. I think that leaves him with the only place being a shelter. And we would ask the court to allow Mr. Ramirez to live in a shelter. The complaining witness in this case, his sister, has said she would be willing to let Mr. Ramirez stay there, but she would have to discuss that with her husband, and she's not sure if that would be a possibility. I don't think that's and I don't think the court would think that would be appropriate either. There were some significant injuries in this case, Judge. There was a small fracture to the wrist of his complaining sister, but she's okay now. The way she explained it to me is it was a simple push, that things got out of hand, that Mr. Ramirez has been dealing with a lot. He's been dealing with depression. He's had some losses in his family, his daughter. He's lost his father. And I think he's recently been divorced. And I think a lot of that kind of came to a head. We don't have a lot of criminal history, Judge. I think the last filed case was in 2010. Mr. Ramirez is a 20-year lawful permanent resident of El Paso. So most of his family lives here. All of his ties are here. We would argue he's not a flight risk. He promises to comply with any conditions of his release, and he promises to appear at all future court hearings. And we would ask the court to consider reducing the bond. I don't believe we're eligible for a full PR bond, but we would ask the court to significantly reduce the bond to something that he might afford. And that's very limited, Judge. He's been found to be indigent. Thank you, Your Honor.
Thank you, Mr. Vandenberg.
Thank you, Your Honor. The state would oppose this. Mr. Ramirez has 3 prior convictions. One is 2012 injury to a child, 2009 an AFE conviction, and 2010 is a DWI open container. The state believes that Mr. Ramirez is a danger to his family. He seems to not be able to control himself in these arenas, and he could be a danger to public because of his conduct. The state would again respectfully request that bond not be lowered, Your Honor.
Anything else, Mr. Huffman?
No, nothing further, Your Honor.
So in reviewing the prior history, I see some type of revocation on probation. I think it was for a DWI in 2010. And all of his prior history is assaultive or involves alcohol use. Considering prior non-compliance, prior history, safety of the community and the victim, I think the bond is reasonable. So your request is denied. I understand, as we discussed off the record, Mr. Huffman, that you might have some additional factors for the court to consider. And if you do, feel free to come back on your bond request. Thank you very much. If we don't need the interpreter anymore, thank you, Mr. Cifuentes. You are excused. Have a good day.
Thank you. Thank you, Judge. You too.
Who's next?
Bottom of page 27, Judge.
Mhm.
Annex, may we have Williams?
Yes.
Thanks, Mr. Bean as well.
What?
Because number 2021-0D01771, State of Texas versus Denzel Bradley Williams. Announcement of council, please.
David Vandenberg on behalf of the state is ready.
Rick Huffman on behalf of Mr. Williams, we're ready.
Mr.
with the Adult Probation Department, Your Honor.
Sorry, Mr. Escobedo, and Mr. Williams is appearing remotely from the the jail annex. We're set for a probation status hearing. Oh, let's start with Mr. Escobedo, I guess.
Yes, Your Honor.
I think I read it. You're recommending continue on community supervision modified to substance abuse caseload. Court is really not inclined to do that. Court, I guess he picked up a DWI and he had a weapon on him.
That would be correct, Judge. He was arrested for the unlawful carrying of a weapon and also the DWIs you previously mentioned.
Okay. Mr. Huffman?
Judge, I have not had the opportunity to meet with Mr. Williams. Maybe the court might consider a release with the mobile unit. But certainly, Judge, we would go along with the probation department's recommendation, and they probably know more about it than I do. But unfortunately, Judge, I have not had the opportunity to meet with Mr. Williams.
So prior to his rearrests, he was also failing to report. He never complied with TAP. So on May 27th, he was assessment and was admitted into TAP. He missed several sessions despite being warned. He was cut on December 1st, 2022 due to his non-attendance. He was given another appointment on April 2023 to be reassessed for TAP, and he missed the appointment. He called to reschedule for May 5th and he missed it again. Failed to report between June and August of 2023. Failure to report letters were mailed with no success. On June 16th, arrested for UCW and DWI. Memory serves, the report was subject down at the wheel. I think they did a blood draw. So not inclined to keep him on probation, Mr. Huffman. We can come back in 30 days if you're going to give me a reason why he should stay on probation. All right. Reset 30 days. Thank you.
Yes, Your Honor. May I be excused?
You may. Thank you, Mr. Escobedo. Who's
Thank
next?
you, Judge.
Judge, on middle of page 26, Mr. Harris I've had no contact with him since 3:30. I've been calling him, Judge, and no contact with his office at all.
Is Mr. Harris appointed? Mr. Vandenberg or maybe Carla, do either of you have, I was trying to find and I did not see the previous hearing. I believe it was August 15th. I'm not sure if I remember, but I felt like I threw out a number on a revo on Mr. Rios.
Let me
Does
look.
anybody have any notes on that?
Let me double check, Your Honor.
Thank you.
Yeah, I'm looking as well.
Yes, ma'am.
Mr. Harris is appointed and Mr. Rios has a new case.
And he has a new case? Oh, there it is. And he's on it, huh? Did Mr. Harris, can someone tell me if he received notice for today's arraignment and pre-revo?
Judge, for the arraignment, Mr. Harris opened the setting on 9/8, and that's for the arraignment.
Okay.
I'll check.
Did we receive, let me see, 9/8 order of court setting, proposed order. All right. Anything come back on the Zoom invite, Mr. Manufo?
He did not open it, Judge. He didn't read it.
Okay. Let's go ahead and, yes, ma'am.
You know what, I do not see any actual rec and a number mentioned.
Same here, Your Honor. I see nothing in our notes.
Okay, so let me go ahead and calling cause number 2023 0D05035, State of Texas versus Refugio Rios Jr. Although I believe Mr. Harris did receive notice of today's arraignment and for pre-rebel hearing, he has not appeared and we have not been successful in making contact with his office. I am going to reset this arraignment for 2 weeks at the same 3 p.m. setting. Let's make sure and get Mr. Harris notice. Mr. Rios already has a trial setting on his new case and the probation cases can carry on from there. But I do want to notate that Mr. Harris did not appear today. Thank you very much. We're adjourned. Who's next?
That's it. This afternoon.